Resolution of the City Council of the City of Saratoga Springs, whereas Title 8 of the Saratoga Springs City Charter entitled Legal Matters establishes how the city shall conduct its legal affairs, and whereas Title 8 states that the city attorney shall serve as general legal advisor and shall be responsible for providing legal services and guidance to the city and all its departments and entities, and whereas the City Council previously established the position of Director of Risk and Safety to coordinate all insurance and safety activity within the city and provide a resource for each commissioner to implement safety rules and regulations within the departments. And whereas this council finds that it is in the public interest for the position of the Director of Risk and Safety to be under the direction of the City Attorney's Office, now therefore be it resolved as follows. The position of Director of Risk and Safety shall report to and work under the general supervision and administrative direction of the City Attorney effective July 1st, 2022. 2, the City Attorney and Human Resources Offices shall issue a procedure manual consistent with this resolution within 90 days from the date this resolution is duly adopted by the Saratoga Springs City Council. And that's in a form of a motion. Is there a second?
Second.
Just to sort of provide the public with a little bit more information about why I believe this resolution is essential, particularly at this point in our history. I'm proposing that the Director of Risk and Safety become part of the City Attorney's Office because I believe it is imperative that we better coordinate the activities of the City Attorneys and the Director of Risk and Safety. Just to give you a sense of what the charter actually says about the city attorney. City attorney's primary job is to serve as a general legal counsel, shall be responsible for providing legal services and guidance to the city and all its departments and entities. It also requires that the city attorney, and there's a direct quote from the charter, shall maintain regular and updated records and expressly provides that the city attorney shall report to the council on the progress of all legal matters conducted by or on behalf of the city as required. And finally, the charter does not expressly or implicitly reserve any authority or role in the conduct, supervision, or review of legal matters to any other city employee. In fact, if you look at the city charter, there is nothing under Title VII, the Commissioner of Accounts, that even talks about the Director of Risk and Safety. Currently, it's clear that the city attorney is not being engaged in all ongoing litigation that occurs on behalf of the city. And that's what spurred this resolution. The information I'm about to share is based on a publicly available docket that is posted on the Northern District of New York Federal Court website. I invite you all to go see it. It's called PACER, which is the Public Access to Court Electronic Record. So nothing I am saying isn't a public record. It's not private, privileged, or otherwise non-disclosable. But it illustrates why this resolution is so important that we have the city attorney be in coordination with the Director of Risk and Safety. On April 1st, 2022, a member of the City Council, without any authorization by any other members of the City Council or involvement of the specific department that was being sued by a former employee, met with the Director of Risk and Safety and attended a settlement conference in a years-long litigation matter before the U.S. District Court of the Northern District of New York without informing, prior to the hearing, any City Council member or bringing the city attorney into the discussions. Based on the docket of the Federal District Court, it seems apparent that a settlement conference was held and negotiations ensued. Now, based on the publicly available docket in this litigation, it appears that another critical date is about to come up in this case. On or about July 7th, 2020, the city will need to take action on this litigation to ask the court to discuss the matter. In the way I read the charter, the city attorney's office should be involved in that discussion. It has not been involved at this point. It's imperative that we as a city council make sure that no litigation is handled or resolved without the involvement of the city attorney and or the other members of the city council who would have to approve any final disposition as required by the charter. Under the current structure in which the Director of Risk and Safety works directly for the Department of Accounts and not the city attorney, we open the city to substantial risk, as shown by the example above, where a city council member with a Director of Risk and Safety attempted to resolve a legal matter without involving the city attorney's office, any member of this city council, or the specific department that was the subject of the litigation that was now being discussed in the Northern District of New York before a magistrate.
Bring it up with a council member.
I'm sorry, there is no public comment at this point. So the reason that it is imperative that the city council act, I believe, and also do it now, is because if we don't, this case will continue to go forward without the involvement of the city attorneys. And that is not tenable, both from a charter standpoint and also good legal practice would require that the city attorney's office be involved. So that's why I bring this motion forward. I've got a second. I don't know if there's any comments or questions on the resolution.
I just want to say, I want to ask you a few questions about this. So this is in no way a reflection of Marilyn and the incredible work that she does for our city.
Not at all. And one thing is, if you know, I you know, to your point, Commissioner Sangvi, I can reread the resolution, but there's nothing in here that says I'm defunding or that the resolution
So you're
is
not
trying.
defunding the position?
Not defunding. We are moving a position to better coordinate with the city attorney's office, where essentially we can protect the city better.
Will you hire another city attorney?
Can you? There is no public hearing at this point.
So Marilyn has been with us for several years, and has done an incredible job. And
Absolutely.
I want to put that on record that this is not in any ways an indictment about her. Right?
And
Is
I
that
would
correct?
completely agree with that. I would completely agree. I was Commissioner of Public Safety from 2005 to 2009. I worked with Marilyn Rivers. I tell the story that the first person I met after I got elected, came over to my Long Alley office, was Marilyn Rivers. Hadn't even met the chiefs yet. She came in to tell me the problems that the city was confronting at that time. We had several lawsuits, and she was there to brief me on those. I have no problems with her work ethic or what she's doing. I want to make sure, though, that the city attorney's office is involved in, seems pretty clear, litigation.
So
can I talk?
Sorry, can I just finish? I'll just finish. And the reason I'm bringing this up and checking with you again and again is because I've got several emails from members of the public. And so I want to confirm with you that your intent is not to defund, that your intent is not to in any ways and a retaliation or in any form something about Marilyn and her performance.
Well, let's examine that. First of all, we did actually take action like that, as a speaker pointed out. That would still come before the city council, so it's not some kind of action that a mayor or a city attorney or anyone could do anyways. So, and as far as any intention, that's absolutely not part of this. What it is really is the idea that we've had basically I would argue, two different law firms working under the same roof. They should be put together to essentially serve the city in a manner that protects us in the best way possible.
All right, may I speak now? The person you're speaking of is me. I'm offended by the characterizations that you just presented to the public because they're materially false. An email was sent into the city by the court requesting my presence at that session. That email was sent to Brian Kremer, the employment attorney for the city, to Marilyn Rivers, risk and safety director, and to Tony Izzo.
Did you tell anyone else about the hearing, the settlement hearing?
That was then forwarded to me, at which point in time, I called up the attorney representing the city to ask, is this something I'm supposed to go to? And he said, yes. So while I could have sent an email around to everybody to ask for permission, when a federal judge asks me to appear at a session, I'm going to go.
So
I didn't interrupt
okay.
you. I didn't interrupt you once.
Okay.
Okay? I went to that session. I provided testimony on a specific issue related to an endorsement meeting within the Saratoga Springs Democratic Committee that I've shared on numerous occasions. Commissioner Scirocco was also supposed to be at that session. He did not, unfortunately, make that session because of his health. But to suggest that I did not try and integrate or communicate with the fiduciary and functional elements of this case is simply false. And the suggestion that I did something wrong or functioned in a way as a mediator is patently untrue. But let's look at the merits of what you've put forward here. First off, it violates service law, and by that, civil service law, and by that the New York State Constitution we've all sworn to uphold. It violates our charter. This is a managerial process. This is something we could have worked out internally, because I have repeatedly said I'm more than happy to share the legal aspect of that with you, but there is so much more to the risk and safety program than the legal elements of it. When Travelers, our insurer, brings lawyers on, they are representing our interests, but they are representing themselves. That is the way our insurance program works. We have a deductible insurance program. Once we pay $25,000, we don't have a say in what they do or how they choose to go about doing things. But I think it's very important for people to understand. In the late 1990s, the city was in very dire straits from a financial and both a risk standpoint. Our insurance was over $1 million a year. We had lost the ability to be insured by legitimate insurers, and we were with the insurer of the insurer of last resort, NYPIR, New York Public Insurer Reciprocal. Basically, we're self-insuring ourselves against risk. Okay, we're paying more than $1 million a year 20 years ago. The reason why is because this function was not being taken seriously. We did not have a formal risk and safety management program. It was managed by the city attorney's office, and it was acknowledged back then that this was a major problem. And so in 2002, and I'm going to read this. In 2002, the City Council has seen property, casualty, and workers' compensation insurance costs increase by over 50% over 2001 levels. This is the result of adverse loss experiences by the city and changes in the commercial insurance market caused by the recession and the events of 9/11. These costs are currently budgeted through the Accounts and Finance Department and does not include employee benefits insurance. In response to this situation, Stephen Town, Commissioner of Accounts of the city, established a committee with the following mission. Recognizing that city government with its full range of services is considered a high-risk operation, the Risk Management Advisory Committee will seek to generally review losses facing the city from a property damage, legal liability, automobile accident, employee injury, and management control currently in place. Recommendations will be made to the City Council on how best to organize risk management activities to reduce accidents and claims and to control insurance and costs. Okay, these activities, and again, this continues on. Saratoga Springs City Council first adopted a safety policy in 1979. In 1989, a safety policy study committee was appointed by the City Council to review the city's safety policies and procedures. In 1990, the City Council approved the study's committee recommendations for a safety program for municipal departments, city safety program activities, and reporting of job injuries. These activities were largely the result of the last hard commercial insurance market in the late 80s. And when the city found its insurance options limited, It was forced to accept high self-insurance retention program and pay most primary property and liability claims out of pocket. So you can't even budget for these items, okay? With the return of a soft insurance market in the 90s, the city was able again to secure reasonably priced coverage with no or small deductibles and activity of the safety committee, and activity of the safety committee and implementation of safety policies and procedures was limited. As a result, the number of employee injuries and automobile accidents, claims, and litigation from city properties and operations increased during the latter 90s. Okay? So much so that in 2001, St. Paul Insurance Company, the city's insurer at the time, conducted a loss control program evaluation, including the interviews with key people in each city department, a review of safety policies and procedures. I want to add, this is what the business world's been doing for about 40 years. I come from this world. I do this professionally. The things that we have set up over the last 20 years have made us safer as an employer. They have made us safer as a community. And not only that, but now today we spend $1 million a year. Okay, remember 20 years ago I said we paid $1 million a year? 20 years later, we're paying $1 million a year now for better coverage. And it is the direct result of the work of our risk and safety management program. And again, the things that risk and safety managers do is they trace losses. They want to understand the root cause of why someone is tripping and falling. Why are we having automobile accidents? Why are we having these claims? That is a process. That is not a legal process. That is an engineering process. And this is something that belongs within this department. It is an oversight. And again, I can read object after object, but recommendation number 1, that the city adopt a revised safety policy statement, copies attached, that will reflect a strong commitment to a safe city program to reduce employee injuries, automobile accidents, property damage claims, claims or litigation related to city premises, contracts, operations departments, or commissions or boards. The safety policy statement, the city reestablishes a safety committee. That's something that has made material gains for this city. Every single person that works in this building, every department participates in that. This is a major improvement that is viewed as a best practice by travelers throughout New York State to the rest of the communities in New York State. The city shall authorize the following position to implement the safety policy and Safe City program. City risk manager will consolidate and assume the responsibilities of the existing insurance coordinator and designated safety officer coordinated, both positions that existed within accounts. This position, under the direction of the accounts commissioner, will be responsible for insurance purchasing and will chair the safety committee and will report to the city council monthly on progress of the Safe City program and recommendations to the city council. They also established the precedence of a human resource administrator, and they put that person in the mayor's office. Why did they separate those powers? Because they understand the need to have separation of powers. We have the commission form of government we have. I think everybody can recognize their shortcomings. There's not a reason to change it, and I do not believe we have the right to change it at this table. The city's voted on this a number of times, and quite frankly, I think the issue is settled.
Quick question, Dylan. Was this changed with a charter change, or was this changed through resolution?
This was changed after. This was adopted. This was post-charter change. So
No, I'm
getting back to
I'm just trying to understand. So this was changed by city council, or it wasn't changed?
5-0.
Okay.
Adopted.
And, sorry, I'm just trying, guys, I'm just trying to understand. I'm not trying to pick anything. I'm just trying to get a handle on this. The risk and safety program and the insurance, because I know all of these questions are out there, and since they can't ask them, I'm asking them. The insurance company, because I saw the correspondence that you had provided, thankfully, from the insurance company. Will your resolution change the risk and safety management program the way Dylan has described it?
No, not at all.
But why are you asking for a procedure manual that already exists?
Because the litigation activity that the city attorney must engage in has to be defined.
So why can't
Because
we
in
define
this
that?
case, well, we did. As you know, I proposed a different resolution the last time, and you were against that one, too.
Ron, the last time you brought it up, I called you up to express the fact that Travelers had contacted me to say that they had major problems, and can we talk? And that was the last time we had a civil conversation.
Sorry, 1 second. I just am trying to get a handle on this. Is Travelers opposed to this resolution? Do we have any data on that?
I haven't.
Have they said anything to us?
Travelers is opposed to the loss of the risk and safety manager. I know that the mayor has told me personally he does not believe we need a risk and safety program. We're not big enough and we don't need it. You said those words to me on the street right out there.
Credibility is so important, and I think the public should know. Commissioner Moran said earlier today, just a few minutes ago, that he was invited by the district court judge to the settlement conference. I can tell you that is not true. I can tell you that there is a letter on the docket that essentially does not support that. I can tell you that, in fact, credibility is very important. And I'm the one who's telling you the truth. So what has been read to you for ad nauseum is a Risk Management Advisory Committee report passed by the city council. Well, we're a city council. Just like we can change what a previous city council did, we can change this. What I, however, read to you in my resolution is the charter, which the charter lays out what the city attorney is supposed to do in cases of litigation. And then I gave you the example of where the city attorney was completely left out.
He was the first
of
person
a negotiation that would have settled the case on behalf of the city and a department that wasn't even the accounts department. So again, credibility is important. And by the way, again, I'm quoting from public documents that are easily accessible through PACER. You can go and see who's correct. You can go and see whether Commissioner Moran was invited by a district court judge to a settlement conference. You can see that because that's simply not true.
Right. So the last thing that you brought before the city council was on the basis that it was justified by Carolyn Casey versus Unitech, EDPA 2015. And you said that our risk and safety manager was practicing law without a license. And you made that statement repeatedly out loud and in easily foilable written emails. This is the response from the lawyer who is the lead attorney for Travelers as it relates to that case. In this Pennsylvania action, asterisks, Saratoga Springs is not within the legal jurisdiction of the state of Pennsylvania and is governed instead by the case law of New York, the Northern District of New York, and the Second Circuit Court of Appeals. Therefore, holding this case even applicable is not persuasive law in our jurisdiction. Plaintiff Casey brought a discrimination claim against her former employer, Unitech. Casey had a law degree, but was also a highly trained risk manager. She was employed by Unitech not as an attorney, but as the vice president of risk and safety. In the course of litigation, Unitech moved for a protective order claiming that Casey was employed to an attorney and should be prohibited from using attorney-client privilege communication to prosecute her claims. This motion by Unitech was denied. The judge enunciated the standard for attorney-client privilege. The privilege applies to any communication that satisfies the following elements. It must be 1, a communication, 2, made between a client and the attorney for his agents, 3, in confidence, 4, for the purposes of obtaining or providing legal assistance for the client. The judge held no such attorney-client privilege existed between Casey and Unitech because Casey was not Unitech's attorney. The judge noted that Casey was not employed by Unitech to be his attorney, but rather was employed as the risk and safety director. In performance of a job as a risk and safety manager for Unitech, Casey managed the litigation of insurable claims against Unitech, including the receipt of court notices, communications with counsel to verify pleadings, make discovery responses, and grant settlement authority. Casey also attended quarterly litigation meetings wherein she would receive confidential communications from outside counsel regarding the status of claims. The court noted that while her position as a risk manager may look quasi-legal, her involvement in the claims were not as an attorney, but instead were as a risk manager to facilitate the conduction of litigation with the insurers. He included that Casey was in essence a client to outside counsel. The judge also noted that Casey's presence at litigation meetings and proceedings was to make strategic business decisions regarding litigation, and her presence was not for the purpose of rendering legal advice to Unitech. In essence, this case speaks solely to whether or not an employer can claim attorney-client privilege over communications with a former employee who is not acting as their corporate attorney. The case is wholly inapplicable to any issues of a client-attorney privilege in the context of insurance litigation involving the City of Saratoga Springs and the Director of Risk and Safety. And I also need to add this personal note from Ms. Murphy. I've attached a copy of my review of Casey versus Unitech. As my review states, I find this case to be wholly inapplicable to the City of Saratoga Springs in relation to the interactions involving the Director of Risk and Safety. In this case, which is not even persuasive law in our jurisdiction, speaks solely to whether or not a corporate employer could claim attorney-client privilege to prohibit a former employee from using communications against a corporation in a discrimination suit. In my opinion, any and all communications between a city employee and an attorney representing the city in litigation, in anticipation of litigation, were fully protected by attorney-client privilege. That is what you stated as a concern. The suggestion that there was ever some sort of attorney-client privilege which could cover communications between one employee and a second employee, and this non-existent privilege is somehow at risk, is simply erroneous. The city faces no risk of losing any attorney-client privilege regarding communications between the Director of Risk and Safety and outside defense counsel. I'm also happy to address the recent proposed resolution. I've been representing the City of Saratoga Springs as the Travelers Staff Counsel for 13 years. I have defended the city in over 150 cases in both New York and federal courts. At any given time, I have an average of 8 to 10 pending cases. From the inception of a case via notice of claim through trial and appeal, I have worked closely with the Director of Risk and Safety to serve and protect the interests of the city. The success that we have had in defending these claims is substantially related to the fact that the city has an individual employee who is dedicated to assist counsel with the management of these claims. The role of a risk manager or even a designated individual to manage claims is essential to successfully defending claims against a municipality. In the cities that New York that employ a risk manager are able to better handle a myriad of insurance claims and risks they face. In my experience, cities do not have designated risk manager, instead have have a depth in their law departments, counsel, deputy counsel, assistant counsels. I think we can all agree that we don't currently have that. That allows an individual to be designated to manage insurance claims. This is not necessary because the outside counsel needs a single point of contact with the municipality to be able to direct inquiries. So what I feel is really important about this, finally, I am compelled to respond to the accusations that the unauthorized practice of law by the Director of Risk and Safety. I have never observed any instance in which the Director of Risk and Safety in any manner whatsoever engaged in the unauthorized practice of law. Such conduct is governed by New York Judiciary Law Section 478, which prohibits any person from practicing or appearing as attorney at law without being admitted and registered. Further, a person who engages in the practice of oppression without a license is subject to arrest and prosecution under New York Education Law Section 6512. It would be equally true that my participation in such conduct would be considered aiding or abetting, and would as that of all present and prior defense counsel. These allegations of criminal conduct are factually baseless and without merit. The City of Saratoga Springs Director of Risk and Safety Management has conducted herself as any risk manager I've ever dealt with, in that she has actively participated in the management of litigation claims to the benefit of her employer. In my 36 years of practice, I've regularly have risk managers from private corporations or municipalities accompany me to court proceedings, court conferences, mediations, arbitrations, depositions, and trials. The presence of these risk managers in these situations is an essential part of the partnership between the defense counsel, the risk manager, and the claim handler in bringing claims to resolution. Additionally, there have been many instances when the Director of Risk and Safety has felt that the input of the city attorney was essential in a specific aspect of litigation and then immediately facilitates conference of the matter with the city attorney. In the instance where a court requests the presence of a person at a settlement conference who has full authority to settle the case, the court is referring to the insurance company claim handler assigned to the case. As with the vast majority of insurance policies, the authority to compromise an insured claim rests with the claim handler, not the defense attorney or the insured client. And while the input from the risk and safety manager, the client, or defense attorney are taken seriously, the ultimate decision-making rests with the claims handler.
So are you arguing, Commissioner, that if the insurance company said, we're settling a case, and that the city council would not have to approve that settlement?
Depends on the circumstances.
I want what circumstances
In the case of
well, let me finish. What circumstances would the insurance company be able to settle a case without the city council, who's been elected by these people, would have to approve? Give me that circumstance. I want to understand that, because you're reading what the insurance company.
After.
No, please stop.
Please.
We're not taking public comment here.
After we've this is not a public forum.
Can you schedule one?
We may. That's a good idea.
Just, please stop. We're not responding
have
to the
talk,
public right now.
Okay?
In a case like the Wales case, and again, to be naming cases is untoward to begin with, we've already expended the deductible. This is their money they're talking about. This is their money they're making decisions with. They do not have to come to us to seek settlement. They would, they could, but they are not required to do so. Further, the notion that Maryland has not been supplying these materials to the city attorney's office is strictly false. She had 3 meetings a week prior to our arrival into City Hall, and with that, she has spreadsheets. When you asked for one, it was immediately provided to you, and those also exist within the city attorney's office. Now, we understand there was turnover in the city attorney's office when we first got here that caused all of us a great deal of trouble, and I don't think right now is the time to dump more work on them. I don't. It's ridiculous.
Again, this resolution has nothing to do with the risk and safety, the Director of Risk and Safety. It has everything to do with the proper handling of litigation in our city, and that should be under the city attorney, period, end the story. So I want to just suggest to you, one of the things that, and maybe we should have a public forum because there is a lot of information here that really needs to get out. I want to also just note for the record, you mentioned the Wales case. I did not. I believed that was basically a client confidence. I talked about the issues relating to a case that I found very disturbing and still do, and the reason that I am urging this city council to act today. But I do want to also mention that when I approached several of the city council members about a way to resolve this problem, the first wasn't to simply change positions. It was actually to set some rules. I got a very strong recommendation from Commissioner Montanino that, in fact, we ought to do this resolution. And unfortunately, he's not here tonight. He did say, I did contact him. He's overseas. And here was his response when he heard that, essentially there's all this kerfuffle. The charter makes clear that the city attorney is a mayoral appointment. Charter, underscored. The charter is silent regarding risk and safety. That is simply just a fact. There is nothing in the charter that discusses the Director of Risk and Safety or risk and safety. I challenge you to look at Article 7 of the charter. It discusses the accounts department. There is nothing about risk and safety. Those words do not appear.
Insurance does, though.
But I am making a statement of fact that risk and safety does not appear. The charter is silent regarding risk and safety since the issues addressed by both the city attorney and risk and safety overlap, and that was This is Commissioner Montanino's observation. it would only be reasonable that the two offices work under the auspices of a single department such as the city attorney. Inasmuch as the mayor's authority over the city attorney is prescribed by the charter, the office of the mayor should be the locus of risk and safety as well. So Commissioner Montanino was not here. He unfortunately, and he will be back here at the next city council meeting, and he supports this resolution. I want to make sure that we have a full vote on this. So I'm going to pull this right now, and we're going to vote on this when he comes back, because I know he supports that. So I will pull it, and
Can we have a public hearing or some sort of a, because that seems to be.
and certainly we can talk. I suppose I can convert if we all agree to.
I can
set a public hearing on this issue.
But you're asking us to violate civil service law and the New York State Constitution by voting.
And certainly that should be you should describe, because you also said we're going to violate the Constitution. So I would like to know how we're going to do that.
And civil service law is written into the New York State Constitution. You don't know that?
So we've had Labor Council advice that the civil service issue is not a block to us to doing this. We've also, and as I said, I'm happy to hear how this resolution would violate the state constitution. So to your suggestion, Commissioner Sangvi, I believe we should set a public hearing so that we can have a full airing of these issues and talk about what happened, not only in the specific instance that it basically spurred on this resolution and all the ramifications of what occurred in that hearing, but also you can discuss how this would violate the state constitution. So I will convert my motion, a discussion and vote, to essentially set a public hearing, unless there's any objection, and we'll set that public hearing.
No, I want to vote right now.
Can we get some
actually like
information?
to-
It's my motion.
I'd actually like to
Oh,
talk
I'm
about
sorry,
this as well. So the thing I've said to Ron pretty much from the beginning is that I have a process problem with this. If at the end of the day, we go through the right process and it makes sense to put risk and safety under Tony, then so be it. I don't think this is the right process. Let me give you an example that's independent of what we're talking about right now. We have 5 department heads here, okay? And say one of them is Republican and 4 of them are Democrat. The way we're operating right now, Dylan can say, I want something that's in the Republicans' department. I want
IT.
IT in his department, okay?
Hey,
Now, I'm being
I'm
serious.
responsible for all records.
Right, so now you've got 4 Dems and 1 Republican.
Peace to me.
And we can now bring this to council and have a vote and move that person or that department as we wish. That isn't a fair process. That doesn't sound like the right process. Maybe that is the process, but it's not a process I'm comfortable with right now. The other piece of the process is I talked to our head of HR, and she believes that this is an issue for the Civil Service Commission because we have 2 department heads who don't agree on where an employee should sit. So this has happened before where the 2 employees, the 2 department heads did agree, and this moved forward smoothly. This is not that, as we've seen. And so for me, once again, we need an independent arbiter to look at this and determine, does this make sense holistically? Does it make sense to move all of risk and safety? Does it make sense to move 10% of it, which may be what the litigation component is? I don't know the answer, but we haven't even discussed that. So again, to me, someone who looks at all of the facts without all of the friction, I think would be a better solution. The last thing I think I would raise is I don't think Tony wants this job. I don't think he wants to manage risk and safety. He's here. He can speak for himself. The way this has been managed before, there was Vince and there was Tony. And this is not disparaging you at all, Tony. There's no Vince. So to give you more and more and more without giving you additional resources creates an equal amount of risk for the city.
I don't think this is fair.
What do you...
Getting employees, who are.
Directly infected?
We're
Yeah,
making a
it
decision on where
seems
the
to
employee
be-
sits. The employee is going to sit under Tony. How is that not fair?
Because it seems like we're putting people on spot for something that
So let me,
we
so
have to-
let me ask you a question. Has anyone at this table asked Tony if he wants this? And Tony, you do want this under you?
Well, no one has asked me. As far as my personal opinion, let me just state one thing. And I'm going to open up with full disclosure, if I may. In the last roughly 20 years, pardon me, Alan Richards has been to me a highly valued colleague and, much more importantly, a good friend. Also, in the 36 years that I have been walking into this building every day, I've devoted all of my time to helping the members of this council and their predecessors do what they believe is best in the best interest of the public. That's what I do. I'll do what the council needs me to do. I've been doing that for 36 years. I'm happy to help any way you need me to help. With that, I leave it to the council to work out as you see fit. Thank you.
Thank you, Tony. So I think I would sum up, I think there are some significant process issues with the way we're proceeding. I think it sets a really bad precedent for the council to move entire departments' functions from one group to another without having some, whether it's the Civil Service Commission or other independent arbiter look at this, especially when it's something as significant as risk and safety. And the last thing I would ask, and I don't know the answer to this because I've been in this job for about a month, what percentage of Marilyn's role is really touches litigation? Because we've talked about one instance in 19 years where she sounds like she might have overstepped. Maybe she hasn't. But if we're talking about 5% of her role, I would argue we should move that 5% under Tony.
Amen.
And leave the rest of it where it is because it has nothing to do with litigation, and that's what we're trying to solve for.
But to that point, Commissioner, and I appreciate those comments, the first resolution that we proposed in May effectively did that. There was no movement of positions. What it did was put the rule book together. That you can go to the May 17th, I think, City Council meeting. You can click on that. That was the resolution. I got feedback from the commissioners saying, better thing is move the position. That was the feedback. So we went back to the drawing board. Now, if people are saying here that the rule book is better and that the rule book can be enforced, I'll go back to that. I'm happy to consider that. But I want the rule book enforced. To your point, Jason, there are other instances. Okay. There are other instances where I believe the city attorney's office has not been involved in critical pieces of this, of what is the central part of their job, which is litigation.
And I agree with you that that needs to be solved for them.
So if the consensus of the city council is, let's not do this and go back to the original resolution that I proposed a month ago, I'm happy to do that. Because I believe it can resolve this problem if people are going to observe it in good faith. And that's the critical part. But I'm open to that process. I'm sorry.
So I'm trying to understand, because Dylan, you provided us information from the insurers, and this is Matt's email where he's advocating. It says, I am advocating for the position of Director of Risk and Safety to be included in claims handling and the insurance program. I'm not concerned with whose purview the Director of Risk and Safety falls under. If you and the council feel the position is better suited under the direction of the control of city attorney, that's fine with me. But he was not okay with the previous resolution. So what is it that the insurance, I thought that, I'm confused, as I'm sure members of the public might be too. Which is the resolution that seems to work for the insurance company?
I think this is a management issue and a policy issue that exists under the table, behind the scenes. This doesn't get played out in front of the community. Let's go back to that one instance. Tony Brian Kremer and Marilyn get an email. Two of the three, Tony, Marilyn, and Christy Spadaro got that email. Two of the three people work for you, but it's my problem? I mean, come on. Let's have conversations. Let's talk our way through this. I'm absolutely on board with the procedure. This is what I do for a living.
Nobody ever told the city attorney or the mayor's office or anyone in that or any of the other city council members that there was a settlement conference and that people from this office were going to attend that. And what I don't understand is how, but apparently you're promoting this unusual theory that just the insurance company can essentially go and say, okay, judge, we'll give them $1 million and the city council doesn't have to do anything about that. I would say
a lot of business by doing something like that. That's an absurd
Well, I
statement.
would say though, that's what I think. I think that's what you said though, and that's the absurdity of it.
No,
I
they're
believe
going
that
to make decisions in their best interest. They
I-
make a calculation on
But
what
there
the
is-
litigation and liability associated with that litigation is, and that is a calculation for money.
there are people that have to sign that stipulation of dismissal to get that settlement.
Ron, I've said repeatedly, I have no problem having you handle every element of the litigation. I'm asking you why, what more needs to happen than him being notified of a situation? Do I have to then come beg? Do I have to come curry favor? I reached out to the attorney who was handling the case for the city, and I said, is this something I have to go to? That's it.
So what I'm going to do is I'm going to pull my motion, and since I'm hearing that maybe people want to go back to my original motion, which, a resolution.
I think that's what we're saying. I think we want to have a conversation.
Here's the thing is, I like the suggestion that we got. We should have a full public hearing. We can have people ask us questions about everything that's happened and why this issue has come up and what city council solutions there are. So I will pull my motion and with the consent add to my agenda to set a public hearing for our next city council meeting, which I believe in the 21st. And we'll set a public
question.
hearing.
I want to call the
I've
question.
withdrawn my motion.
Forum, so we can ask questions.
Sure. And so I'll set a public hearing. I've withdrawn my motion. So now I'm asking the city council if I can add an agenda item to set a public hearing on June 21st.
I mean, I would just go on the record and say we have a process problem here. We don't need the community to weigh in on the process problem. We need to fix our process problem. If Dylan has information and it needs to get to Tony, we need to fix that. If Marilyn has information and it needs to get to Tony and it's not happening, or they're doing things that you think are...
He needs to read his emails. The emails were sent. I have the emails.
I'm sorry. Look, if you want to approach, identify yourself.
No, guys, we can't do this.
Let her speak.
Can we?
Let her speak.
Can I? Okay, so I'm going to allow, since Tony spoke, I'm going to allow Marilyn Rivers to speak for 2 minutes, okay? That's only fair, I think.
No,
Would you approach?
I'm just going to have the objection again that I feel bringing employees into this forum and doing this
Well,
is
she
unfair.
wants to talk. I'm
And
not
if
talking.
Marilyn wants to talk, that's fine. I'm just letting you guys both know, all of y'all know, that does not.
Well, we've been
Well.
talking about her for 30 minutes. So.
I understand.
So,
that, but-
Marilyn, if you'd like to approach, you have 2 minutes to speak.
My name is Marilyn Rivers. I'm the Director of Risk and Safety. I have been the Director of Risk and Safety since April 8th of 2003. I have worked with a variety of city attorneys. There has been a traumatic issue associated with the city attorney's office since January. I have always worked with the city attorneys on all of the litigation, and they have been copied on all of the litigation. Every city council in executive session has discussed any settlement involving an insurance claim in executive session with the insurance counsel assigned. I have not worked on any litigation with Tony Izzo since I have started. It has always been with the sitting city attorney. In good faith, I received the email in question pertaining to the court case that you are speaking about. I immediately contacted and provided it to the city attorney. The attorney of record reached out to him and was ready, willing, and able to give him any information. I have provided spreadsheets of all of the litigation, which is only about 5% in all of my 20 years. The majority of my time is spent with trying to recruit streetlights that get hit, or to try and deal with auto accidents or employee safety issues, or work with safety committee members.
15 seconds.
The litigation between risk and safety and the city attorney's office, the discussions have always existed, and an email, those emails are available showing all of those emails going back and forth between insurance counsel and the city attorneys of record.
Thank you. Thank you.
Thank you, Marilyn.
So I've withdrawn my motion. I'm asking for consent, the city council to add a public hearing for June 22nd where we can elicit any public input on this issue. Is there any objection to adding an
I object.
item?
Just the 22nd or 21st?
Oh, am I? 21st, I'm sorry.
I object.
Sorry, what is the purpose of the public hearing?
Well, I think people may have questions out there, and I think we serve the people. So, I mean, that's what
People have us here to get the work done, and we're not doing any work right now.